This is Too Many Lawyers. I'm Roy Oakes, your host. Our co-host Connor Oakes is on special assignment. Well, that was kind of a fib. He's not a secret agent or anything. He's just a busy lawyer, and he's not available this week. But I'm here, and I'm very lucky to have a terrific guest. His name is Bob EGELKO. He is a legal affairs reporter. He's been with the Associated Press and the Examiner and the Chronicle in San Francisco. Bob, welcome to the show.
Thank you.
So you and I go back a ways. We should have full disclosure for our vast listening audience, I think. I first became aware of you when I picked up the newspaper, got my morning coffee. Well, no, I didn't do that because I wasn't old enough to drink coffee. But there you were on the front page, Bob, with my sister Marilyn,
Yeah.
and the two of you were perusing a circular slide rule, and of course, I didn't even know what a regular slide rule was. And I believe you and she were honored for having perfect scores, and it was big enough to hit the newspaper. So maybe that was the start of your journalism career. You think?
I don't know. I guess I had been writing for our high school paper, the Canoga Park High Hunter's Call, for a while. But yeah, Marilyn and I got good scores on the math college entrance exam. Marilyn, because she knew so much, and me, I didn't know nearly as much as her, but I was good at taking tests.
Well,
So
you're being modest because according to this newspaper, you both got perfect 800 scores. So I
oh
mean,
yeah.
how much better of a handle did she have on all that complicated stuff than you if you both got perfect scores?
Well, she knew the subject as well as or better than the people who were testing, and I was very good at taking multiple choice tests. That
All
was
right. So
my
before
skill.
before we get into the nuts and bolts of the really fascinating high-profile trials of the last few decades that I've been bloviating about and you've been actually writing and reporting about, I wanted to just ask you about your choice of a profession. I'm going to hit you with a question, Bob, that Jay Leno asked Hugh Grant when he was caught with a hooker on Hollywood Boulevard. He said, "What the hell were you thinking?"
Yeah.
So you had a perfectly honest, productive life as a math wizard staring you in the face, and you chose to be a reporter and a lawyer. I mean, to quote Ricky Ricardo to Lucy, Bob, you've got some splaining to do.
I can't. I guess so. No, I started journalism. I guess I did a little in lower grades, but I started at the Canoga Park High School, our alma mater, Hunter's Call, which was the newspaper. It was a wonderful place to be, and I just felt comfortable there, uh, writing and editing, and just kind of maybe deciding what events uh, people in the school and in the community should hear about and what perspective they should give. It felt comfortable. And was something, I don't know, I guess the skills that I had seemed to be in describing rather than in doing so much. And
So you went to
feel comfortable.
Stanford, and then I know
Yeah,
you were a Vista volunteer, and then grad
that's right.
school journalism at UCLA,
Mhm.
and then with the AP. And I know you told me you moved over to Sacramento, and then you enrolled in McGeorge Law School, got your legal degree. So there are plenty of high-profile trials we can talk about from the last few decades, from O.J. Simpson and Menendez. I mean, Patty Hearst and Charles Manson, all the way to Sean Diddy Combs and Donald Trump. But I want to start with one that you covered extensively. That's the federal court judicial, that is judge trial, bench trial, not a jury trial, in San Francisco on the issue of gay marriage in California. It was a Hollingsworth versus Perry case. A lot of people will remember. And just to give a quick background, and then I'll let you talk about the real deal. In May 2008, the California Supreme Court ruled same-sex couples have constitutional rights to marry under the California Constitution. So a lot of folks weren't happy with that. So 6 months later, in November 2008, the California voters approved Proposition 8, amending the California Constitution to say only marriage between a man and a woman is valid or recognized in California. So a couple of same-sex couples sued, represented by a pair of unknown, untested lawyers by the name of Ted Olson and David Boies. Bob,
Right.
I always loved the irony of those two, the gladiators who were on the two sides of the Bush versus Gore case, teaming up to defend the right of same sex marriage. So they argued argued the Prop 8 violated the federal constitution. So let me let you pick it up from there. When did you start reporting on the issue? Right around the time Prop 8 was passed? When did you get into the act?
Yeah, I did cover some of Prop 8's uh, passage and its the litigation that followed, which was rather odd because it went to the trial, and I'll get to that. Uh, but after the trial, when Prop 8 was found again to be unconstitutional, uh, and the sponsors appealed unsuccessfully, and the Supreme Court wouldn't rule on its validity. This was in 2013, I guess. Instead, they said, well, these private parties who sponsored it, they aren't the state. They don't have any standing. And therefore, Prop 8 goes down. And I mean, whatever I think about Prop 8, it just felt bizarre. I mean, it taught me a little something about, I guess, the relationship between these legal doctrines and what seem to be the facts. Because to say that the sponsors can pour all this money and effort and emotion into Prop 8, not to mention all the people who voted for it, 52+% of California, couldn't represent the state or the interest of Prop 8 before the federal courts just struck me as counterintuitive. Whatever I thought about the results, I mean, how can you say that they don't have anything at stake? But that's what the Supremes did.
Well, let's go back to the beginning and talk about Judge Vaughn Walker, the federal judge who handled the case.
Uh-huh.
Um, the world later found out he's gay.
Yeah.
What was your impression of the whole controversy and the fact that he was a gay man, a federal judge, presumably by a random lot? That's how they normally handle it. They just spin a wheel and
Right.
pick the random judge. What was going on in terms of his sexuality and his decision? And I'm guessing that there were some people who kind of second guessed his decision and also his call not to take the case and not disclose his sexual preference.
Yeah, well, he was certainly asked about that later uh, when he was brought out, and I should say that a couple of columnists in the Chronicle were the ones who outed him to the public during his
Really?
trial. Uh, Not me. Uh, I don't remember what I knew or what I guessed at the time, but it certainly didn't. It didn't seem relevant any more than saying that somebody was straight. To say that a gay person can't rationally, neutrally judge a trial on LGBT rights is, as Walker said later on, like saying a black person can't handle a civil rights case or a woman can't handle a suit on sex discrimination and things like that.
No, you're right. And I think
Yeah,
now,
yeah,
today, to the people hearing that there was some issue or controversy, it sounds sort of quaint or antiquated that people would
yeah,
even bring it up.
yeah. But uh, given the prevalence of the dispute over anti-gay prejudice at the time, uh, I guess it's to be understood that many people who were pro-gay or anti-gay uh, would assume that someone who had and who wasn't outed, at the time, and who in fact didn't really know he was gay for quite some time because he underwent the so-called conversion therapy.
Really?
Yeah, yeah. He was sent there and wasn't sure, for quite some time, what his sexual orientation was, but he said later on that he knew that it was going to be controversial, but he didn't think he was disqualified from hearing the case.
So you've spent decades in courtrooms reporting on big cases. Paint us a picture. What was the mood like inside the gay rights, gay marriage courtroom? Did it feel like just another constitutional case, or did people recognize it as historic?
The latter, I think. The court was just packed with spectators, and we covered the testimony every day, which is kind of unusual too. But given the public interest in it, it's understandable. And so we heard witnesses. Some of them were couples. A lot of them were academics, or just advocates, including the kind of an interesting witness for the Prop 8 sponsors uh, at the end, and I'll get to him. But a couple of those people later on, after this was all over with, and after Prop 8 was tossed, I said, I think I changed my view. I think I can live with or even support same-sex marriage. It happens to a lot of us, I guess. You see these folks in person, and they're not the monsters or the aliens that
Right.
they,
I want to ask you about the camera issue, the courtroom
yeah.
camera issue. I have a strong interest in it because for basically since the O.J. Simpson murder trial, I've been representing media outlets trying to
Uh-huh.
get cameras in the courtroom. And of course, in federal court, there is a ban on cameras. There are a couple of exceptions. There are pilot programs that go on in various federal districts around the country. Plus, at the appellate level, the Ninth Circuit some years ago decided, well, I guess the world wouldn't come to an end if we televised our oral argument with no witnesses and no jurors and so on. But other than that, it's generally a ban. Now, Judge Von Walker had an interesting take. He wanted it televised, as I recall. He thought it was of extraordinary public importance, and he tried to make that happen. What's your recollection about the whole process of his doomed effort to televise his own trial?
The Supreme Court was the ultimate barrier. Uh, he wanted televised, uh, and the Supremes were very hostile, and they still are, to any sort of cameras in the courtroom. And I want to mention, Justice late Justice Antonin Scalia was, I guess, the most vocal uh, of the opponents. He kept talking about, oh, they'll just do 30-second sound bites, and I guess uh, he probably hasn't read some of our coverage because a lot of the quotes I use and others use take less than 30 seconds to speak. But but nevertheless, they were the barrier.
So you mentioned Justice Scalia, of course, another justice famously weighed in. You'll probably recall Justice David Souter. His quote of note was, "There'll be a camera in federal court over my dead body."
Yeah,
So
yeah.
he was not a fan either.
No, I mean it's true, and I think Chief Justice Roberts feels pretty much the same way, and exactly why is still kind of hard to fathom. I mean, they say we won't get a fair representation of the full case that we're doing. Uh, they'll just show little bits and pieces where maybe there's some privacy uh, involved or security or things like that.
One more question on the cameras involving Judge Von Walker's case. Tell me if you know or recall, how the heck did it happen that after he was rebuffed and the powers that be said, no, we're not going to let you televise your special fancy trial, he actually arranged for, as you were suggesting a few minutes ago, a videotaping of the trial? I mean, what did he set up his Super 8 camera in the back and ask his clerk to run it? I mean, how was that possible when it's not permitted by the rules?
Yeah, I honestly don't know, or at least don't remember uh, uh, the procedure he went through to videotape some of the testimony, but the fact is that it was those videos, not trial from start to finish, that he sought to make public, right after the proceeding ended, and got turned
So
down.
we're talking with Bob
Sure.
EGELKO. He is the legal affairs correspondent for the San Francisco Chronicle. He was with the Associated Press for 30 years. This is Too Many Lawyers. We will be right back. We are back. This is Too Many Lawyers. I'm Royal Oakes, your host, and we're joined by Bob EGELKO. He is the legal affairs correspondent for the San Francisco Chronicle, talking about a bunch of high-profile trials, but principally one he covered extensively, the same-sex marriage trial, federal court in San Francisco. And we talked, Bob, a little bit about the Judge Von Walker. What are your further reflections about him? Because he was such a pivotal, high-profile figure in the whole controversy.
Yeah, well, as I said, Von Walker, of course, didn't come out as gay. Uh, during the trial, he was brought out by some of the folks in the Chronicle, as I mentioned. But later on, when the sponsors of Prop 8, of course, said that he should have recused himself, he said, "I never really seriously considered backing off or stepping aside, and and it was found that he didn't have to, but he conducted this trial with no jury, just questioning the witnesses, and the witnesses included couples. We said, here's what we the first day, one of the first witnesses said he was proud to be gay, but with the passage of Prop 8, quote, being gay means I'm unequal. Uh, a woman who lived in Berkeley with her female partner and their children said, "I do everything I can to be a contributing and valuable member of the state. The state isn't letting us be happy. The neighbors, I think they feel sorry for us, and I can't stand it." A witness for Prop 8 said it was meant to cure society or protect society from, quote, moral and social decay, that allowing same-sex couples to marry would promote. And in the end, after 12 days of testimony and cross-examination, Judge Walker eventually ruled that it was motivated by, not just motivated by bias, but it promoted inequality, and it discriminated on the basis of sex and on the basis of gender. And but oh yeah, I wanted to mention this other witness, a guy named David Blankenhorn, a defense witness pro Prop 8, founder of something called the Institute for American Values. Uh, and he said overturning Prop 8 would, quote, weaken the role of marriage in society. But he couldn't cite any other research, and he actually had published a book, which was brought out during cross-examination.
Bob, one of the things that's discouraging to me, and maybe I'm just looking at things with rose-colored glasses, but the idea that you can pretty accurately predict how a justice is going to rule on a high-profile case based on the party of the president who appointed them is kind of discouraging. I mean, you can almost always predict where five or six of the current justices are going to vote. I don't know what the solution to that is, but the impact, the effect of that, of course, as you know, is all sorts of speculation. Is Alito going to retire now because he wants to make sure that Donald Trump can replace him, as opposed to some evil Democrat who might take office in a couple of years? And as you've pointed out, he might even be looking at the midterms and thinking to himself, Alito might, gee, I better quit now because probably the Democrats are going to get the Senate, and then my replacement will never be confirmed as another conservative justice. Is that kind of discouraging to you?
Well, I think that it at least sheds, assuming that it's true, and I think there is something to it, it sheds a little light on what motivates a lot of the justices. I mean, you simply have to look at the history of some of them. Chief Justice Roberts, before he joined the court, was a lawyer with President George W. Bush's Justice Department, and helped arguments that swung the election to him in the Bush versus Gore case, and then he became Chief Justice. It's not too hard to see his political background.
Bob, I'm interested in your thought on a point made in a National Review article this week, and of course, very conservative journal.
Yeah.
Their point was that Republicans who are beaten up on Amy Coney Barrett should ease off because she's an honest person, who's a smart person, who does good work. And the fact that she votes against their hero, Donald Trump, occasionally it shouldn't be a reason for them to criticize her. But it raised the issue of, if you look back over the last 50 or 60 years, and you're looking for examples where a justice, sort of in a spirit of independence, disappointed the president and the party of the president who appointed them, it seems to be all on one side. I mean, let's look at the record. Chief Justice Roberts famously saved Obamacare twice with his vote. The examples we just mentioned about birthright citizenship and tariffs, several of the Republican appointees, including some Trump appointees, voted with the liberals. When you try to research and figure out, say, since the Kennedy era, well, how many liberals on the court appointed by Democrats have gone all suitor and suddenly become conservative, or even occasionally issued big time conservative decisions? For fun, I couldn't really think of many. For fun, I went on to Chat GPT and I said, "Hey, give me examples of Democrat appointees to the U.S. Supreme Court who wound up disappointing the Democrats." And it was a head scratcher. They came up with something like, oh, I think maybe Ruth Bader Ginsburg voted in an eminent domain case in a conservative way. They said, maybe Byron White.
I was just going to mention Byron White.
Yeah. So he voted in favor of some sodomy law that was a conservative decision, even though he was appointed by a liberal. Does it strike you? Do you think National Review has a point that for some reason, and tell me if you think that you know the reason, the vast majority of disappointing decisions come from Republican appointees? And National Review's point was that, well, they're at least being intellectually honest if they really feel, like look at Anthony Kennedy, look at Sandra Day O'Connor. They saved Roe versus Wade. What's your take on this phenomenon that National Review is identifying?
Yeah, I think that it has something to do with the confirmation process. At least at the time of some of those appointments, Democrats had more power in Congress than they do now. So it would be easier to get a Justice Kennedy confirmed than it would a Clarence Thomas or a Samuel Alito. And even Alito, I don't think had been known as quite as conservative as he turned out to be. Then, so they probably had to nominate justices who had a certain amount of appeal to centrist Democrats to get them confirmed. And the cases that have come before the court, for the most part, haven't called on justices to take a far left stand. It's kind of been center to right. For the most part, there have been a few cases where the court really had taken new steps, like Roe versus Wade, but mostly, I guess, in recent decades, it's a question of, is the court going to stay in the middle, or is it going to swing to the right?
Right. And we've talked a little bit about Justice Anthony Kennedy, and of course, he was at the Ninth Circuit, and he was affiliated with the McGeorge Law School, where you went to law school, and I know you bumped into him over the years. What are your impressions of him?
He was my constitutional law professor in McGeorge in, I guess, 1980, 81, something like that, when I went to law school. But yeah, he was appointed as a somewhat right of center, but he was the justice who issued all of the major rulings on gay and lesbian rights. And I don't think that came up when President Bush nominated him or was considering it, but he turned out to have be receptive to arguments about inequality or prejudice, and that's how he ruled. And
hey, let's shift gears and talk about another case
sure,
from
sure, sure.
misty past, Charles Manson. So one of the memories I have of the Charles Manson case, and from a journalism standpoint, I'd be interested in your take on this. As I recall, Richard Nixon was president, and he made some comment about Charles Manson being guilty, and this was during Manson's trial. Well, somehow Manson got a hold of the headline of the Los Angeles Times, which read Nixon : Manson guilty, and he waved it at the jury. Of course, it was people say the O.J. Simpson case was a circus, but that was nothing compared to the Charles Manson case with carving swastikas in foreheads and so on. What are your impressions? I know you had some thoughts about the parole issues and, of course, the capital punishment change in the U.S. Supreme Court that saved Charles Manson and his followers. So what are your recollections of that case?
Yeah, my recollections are not from the Manson trial, which was before I started covering the courts, but I certainly uh, covered some of the aftermath, particularly the attempts by parole consideration of the Manson family, as they were called. Of course, Manson's life was spared, as you said, when the Supreme Court in California uh, death penalty law was found unconstitutional. They were resentenced to life, uh, and in the case of a lot of the followers, life with the possibility of parole. And it was the parole proceedings that I covered not so much before the parole board, but when they came up to the courts, to the governor's office. The one Mansonite that I guess I talked to, and I don't really remember much about it, was named Lynette Squeaky Fromm, the one who pulled the gun and pulled the trigger on Gerald Ford in 1975 in Sacramento.
That's right. And Sarah
Yeah,
Jane Moore within about the same month. That was a bad
yeah,
month
they
for
said,
Gerald Ford.
and she shouted, "It wouldn't go off." And it turned out there was no bullet in the chamber. And later on, she told the Sacramento Bee she'd actually ejected the bullet from the chamber, and one was found in her home.
Wow.
I don't really remember anything that Squeaky said uh, in jail when I spoke to her. I don't remember that she was terribly frightening, but she did 34 years plus, and she was paroled by the feds because under federal law, once the parole board approves you, you go out. California is different. California is one of two states, along with Oklahoma, that gives the governor veto power over parole decisions.
We're talking with Bob EGELKO. He's with San Francisco Chronicle, legal affairs reporter. Bob, let's do a little lightning round. We've talked about a few cases, but there are so many over the decades. Let me just kind of get your quick hit thoughts on some of them. So let's shift to O.J. Simpson, and let me know if anything stands out in your memory. And I'll start by telling you the things that stand out in my memory. Number one, the district attorney blew it. Under the law, he really should have tried the case in West Los Angeles because you're supposed to try cases in the venue where the crime occurred. That's
Mhm.
part of the whole jury of your peers thing. Now, there's some flexibility. You can try it in downtown LA under some various technical aspects if you want, but really, the district attorney at Gilgar said he should have tried the O.J. Simpson murder case where the crime happened. Instead, for a bunch of various stupid reasons, like his political ambitions, he didn't want to be seen as assembling some white racist jury. He thought he was overconfident. He thought we could win this case anywhere. Look at all the blood evidence, etc. So that's first impression for me. The second impression is, how does a jury, after a couple of hours, and we're being generous here, a couple of hours of deliberation between ordering a ham sandwich and picking the four-person and taking the vote, there was time for maybe a half hour, 45 minutes of deliberation after 9 months of incredibly convoluted, detailed, DNA. It was like a junior college biology class. My concern was that it was a payback verdict where they thought members of the jury, the LAPD, had been racist for years, and they may well have been right. And at the end of the day, do they want a smile on the face of racist Mark Furman based on their verdict, or O.J. Simpson? So those are my takeaways. What do you recall principally from the O.J. Simpson drama?
Not as many details as you, but I think the impression is kind of similar. You decide who's on your side, kind of, and what do you think of this person, and what about the other players involved? But yeah, I guess I was somewhat surprised as well, and that is the way the system works. But there've been no end to jury verdicts. I couldn't start naming them to you that have could have astonished me over the years. I don't think I've ever been on a voting member of a jury myself, but just the idea that somebody could acquit OJ given the evidence, or come to some of the conclusions that, that they've come to in other criminal and civil trials.
Hey, last topic I want to run by you, Bob, is Rodney King. And you're going to think I'm obsessed with the subject of venue, given my rant about how DA Gil Garcetti was wrong to pick the venue of downtown LA over West Los Angeles, where the O.J. Simpson murders
Yeah.
actually occurred. So in Rodney King, you will recall that they beat Rodney up. The cops go on trial in Simi Valley. The jury says not guilty. There's a huge riot, the biggest riot of the 20th century in Los Angeles.
Right.
The feds come along and say, hey, congratulations on your victory, officers. You're under arrest. We're trying you in federal court. And of course, they say, what are you talking about? What about double jeopardy? No, no, it's not double jeopardy. Separate sovereign system. We get to try you at the federal level as well. You deprived Rodney King of his civil rights. So now we are in federal court in downtown LA. And the defense confidently strides into court and says, hey, Your Honor, good afternoon. Nice tie, Your Honor. Here's our motion for change of venue. Kind of a no-brainer. You pick the spot. I like Biloxi, Mississippi, or Bismarck, North Dakota myself. And the judge says, oh, no, we're keeping it in Los Angeles. And the defense lawyers say, whoa, wait. The town is barely returned to room temperature. You think you're going to get a jury in Los Angeles who is not going to be fearful that if they vote not guilty, there'll be an even bigger riot? And the judge says, not to worry. Well, he spoke an Australian accent, which I can't do because you may remember he was from Australia. He actually won a gold medal for Australia in swimming in the Olympics in the 50s. And so he says, oh, no, we'll work really hard. This voir dire process will be great. We'll get all the people who are afraid out. And of course, what happened, Bob, is when the jury buzzed their little buzzer and said, okay, we've got a verdict. It was a Friday afternoon. And, Friday afternoon verdicts, that's the thing. People want to get out of Dodge, right?
Yeah.
So the judge says, assembles everybody. Yeah, counsel, the party. So we've got a verdict. And he says, we're gonna unseal it tomorrow morning at 7 a.m. So have a nice evening. And the lawyer said, what 7 a.m. on a Saturday? Yeah, that's right. I'm going to go put a shrimp on the Barbie. Have a nice day. And that's what they did. And, 7 a.m. the next morning, when all the gangbangers were asleep, they unsealed the verdict. And what a shock, guilty.
Mm-hmm.
So my take from Rodney King, I think the cops were guilty. They were beating up the guy and he was virtually not moving for like a minute or two.
Yeah.
But don't you think that they deserved a jury in federal court that wasn't afraid that they would be triggering a second riot? Or do you think I'm just being crazy here?
Well, I think that it's a legitimate concern. On the other hand, the first change of venue was, kind of accomplish that task in reverse. You move it away from from the place where it happened,
Right.
and you're less likely to hold the officers to account, I guess. And we all saw what we saw, uh, but yeah, it's pretty bizarre. And in federal court, there's just fewer controls. You can't vote those judges out, uh, and they know it. And particularly when it comes to decisions that might make a guilty verdict more likely, there's very little that one can do about it. So yeah, it was certainly strange that the grounds that convinced the state court to change the venue and following the riot didn't seem to move the federal judge. But there's not much you can do about it in the end unless you run into a really sympathetic panel on the higher court. And let's face it, our federal courts, at least at the top, have had fairly conservative majorities for decades. And they do it even more now than they did then. But
Right.
even then, so if you lose one of those things, it's pretty tough to get it overruled. And yeah, I hadn't remembered the 7 a.m. Stuff, but I guess
It was an early wake up call for everybody.
yeah. But in any event, I guess all I was thinking of at the time was I'd seen what happened, and how could the state jury have possibly reached that verdict? And whatever doubts one might have about what the judge did, it just seemed like having some sort of a federal jurisdiction over this case was a backstop. It was a safety factor to ensure that some degree of justice might be might be possible.
One could draw an analogy of the O.J. Simpson stealing his own stuff trial in Nevada was kind of
Yeah.
a backstop. He served 9 years for stealing his own stuff, and if it
Oh
hadn't
yeah.
been O.J. and if he hadn't beaten the rap in the murder trial, I kind of doubt that they even would have made charged him
Yeah,
much. On one P.S. on O.J. Simpson, my favorite fun fact is, after he got paroled by Nevada after I think 9 years,
yeah.
he and his buddies decided to celebrate at the Cosmopolitan Hotel there in Vegas. And you may know their advertising slogan is just the right amount of wrong. So
Uh,
OJ and his friends are really having a great time. I mean, I don't know, how often do you get out, 13 years early?
yeah.
And they bust up the place. They break all sorts of glass and mirrors and so on. And so the Cosmopolitan bans OJ for life.
Yeah.
And you may remember he sued them for defamation for destroying his reputation.
Yeah,
And
well,
they reached a settlement.
oh,
Hey, Bobby Gelko, thank you so much for spending time. And you mentioned objectivity. You may know this, but there's a great craving, a great desire out there across the fruited plain for objective, smart reporting, and you've provided that for decades. And thank you for that, because it's so hard these days to find objectivity. I mean, without naming names or letters, let's face it, most or many news outlets you tune into or read, you're just getting propaganda. And it's really frustrating for a lot of people in America that there are very few places where you can just get the straight story. And you've been providing that for a long time, so thank you very much for that.
thank you for inviting me, and I appreciate the kind words, and I hope I live up to them.
All right. This has been Too Many Lawyers. We'll see you next time. I'm Royal Oakes. Take care of yourselves.